I trust you've all had a chance to go through the slides and work on the tutorial question. So we'll jump right in. So this week, what we're looking at is, or what you would have looked at over the past week, is methods of securing attendance of the accused in court. Now, why do you think it's important for criminal justice that we consider this? Why do you think it's important that an accused person be in court? Have you gone through the audio and the slides? Because one of the rules of justice, one of the rules of criminal justice is audi alterum partem. In other words, hear the other side or hear both sides. And as far as criminal law is concerned, that further is extended or is given greater field in that the accused person must be present to hear the charges brought against him, hear or her, hear the witnesses, hear the testimony, and in that light be able to make a case to defend those allegations. So naturally, it would be important for us as criminal lawyers and as the system of criminal justice to have methods or ways of ensuring that an accused person does come to court on that day. So the trial can't proceed in the accused person's absence, although there are exceptions. We're not going to be looking at those exceptions right now. It is ideal that the accused person be present for his or her trial. The trial cannot begin, cannot proceed when the accused person is absent. And I said that there are exceptions, which you look at through in the slides as we go through the audio. But if the trial can't proceed because the accused person is not there, it means that the victims of this crime are not getting justice because the matter is never able to proceed because the accused person is absent. So as we said that there are, in the criminal justice system, it is a system. There are steps that need to be followed, and we talk about pre-trial, pre-trial and investigation, the trial, post-trial, etc. And what we're leading up to is the trial, but things like arrests, which is what we're going to be talking about today, things like arrests are deemed pre-trial, but pre-trial till the cusp. Beyond that, we also been looking at later stage at searches and seizures, etc. So we see that there are different phases, different stages, and we're looking now, still in the pre-trial stage, about how do we get the accused person to court. There are several ways in which an accused person can be brought to court. Summons, written notices to appear, indictments, arrests, warnings. Okay, and we're going to look at each of these in turn. And what we need to focus our thoughts on, or focus our consideration of which one to use and which one is most appropriate versus most effective, will come down to a balancing of rights. Rights of the accused person, or rights of the suspected person, and the rights of the community and rights of the victim. And so we will be considering the constitutionality of each of these methods of getting an accused person to trial. The summons is the first one that we look at. Now, summons is a written order from the court instructing, or rather directing, that a person who is named in that document appear at court on a certain date and a certain time. So that's essentially what a summons is. When is it used? It is used for our purposes in criminal matters when the matters aren't, when it's not a very serious crime, or when there's the risk of an accused person absconding and evading trial are not that high, are not that high. So go through the audio and look at the notes that I've given you as well on the step-by-step process of how a summons is issued and how it is served, what proper service means, what happens if you are given a summons and you ignore it. Look at what we say about admission of guilt fines, etc. Another type of written notice is the written notice. So if it says a summons was a written notice, a more specific one is called the written notice, but it does differ from the summons in that a written notice has built in a phrase or a section that allows for an admission of guilt fine, an admission of guilt fine. And again, it is used in less serious offenses, right? But where it is anticipated that if found guilty at a trial, the court would prescribe a fine as punishment as opposed to jail time or some other type of custodial sentence. Again, look at our notes to see what the content of these written notices are. So have you seen one of these before? Have you seen one of these before? Any of you drive? Okay, I can't toggle between the chats and things. So if you want to say something, just please, like I said, unmute yourself and chat. Yeah, it's a speeding ticket. It's a traffic fine. That's correct. Now, in that traffic fine, you need to work out whether what you've been issued with is a summons or a written notice, right? If it's a written notice, there will be in it a portion for an admission of guilt fine. There will also be, and that's its payment date, there will also be on one of the other sides a date at which your court date is meant to happen. Now, if there's a court date on it, then that's a summons. If it doesn't have a court date, it's usually just a written notice. But you'll see here, right? That's the portion that you're looking for. What is important, and I'm not going to say it again here because it is on the audio, it is in your notes, and it is in your readings, is what is the effect? What is the effect of signing and paying an admission of guilt fine? What is the effect? Is it just paid and over and gone? No. If you pay an admission of guilt fine, you now have a criminal record. A criminal record. So although a traffic violation may not seem to be a serious offense, it is a criminal offense nonetheless. And you will find soon when you are looking for articles or when you get articles and you've got to get your paperwork in order, you've got to get a certificate to show that you don't have a criminal record. Traffic violations, unfortunately, will show up on those ones. So the question about the constitutionality of that aspect, where you pay an admission of guilt fine for something as not serious, I can't think of a better word, minor, not serious as a speeding fine or a parking fine, should those form part of your criminal record? Okay, and we know that there are other plans in place that the various traffic departments from the municipalities have been talking about regarding the point system for traffic violations. That hasn't come in, but we'll have to see how that transpires. So the difference essentially between a summons and a written notice is a written notice, accused persons are given a choice: pay a fine or come to court and defend. And a written notice is written by a peace officer, and that's what the spot ticket that the police officer would give you. That's an example of that. Summonses are more formal. They are made by the clerk of the court after having received the docket or the file or the properly drafted charge from the prosecutor's office. Okay. Indictments then are very similar to summonses, but where summonses emanate from the magistrate's court or the lower courts, indictments emanate from the high court, right? And in both cases, failure to appear results in a warrant of arrest. And that brings us to arrests. What is an arrest? An arrest is also another means of securing the attendance of an accused at court. Okay, and I just said another means, but it's also the most drastic means. Drastic in the sense that of all of the options available to a peace officer, an arrest is the one that violates against the suspect or the accused person's constitutional rights the most. What happens when someone is being arrested? Describe that to me, if you can. Anyone?
Can I try?
Go ahead, Fezeka.
I think you are taken against your will, and you basically put in a place where you don't want to be. So that's an infringement of I'm not sure which right.
Yeah, your right to freedom of movement, your right to bodily integrity. If someone other than a police officer were to grab you and throw you into the back of the van, what would you think is happening to you?
I'm being kidnapped,
Yeah,
abducted.
kidnapped. Well, you're an adult.
Yes,
You're being,
I'm being kidnapped.
you're being kidnapped, you're being assaulted, right? So for effective policing, we accept as a community, as a society, and as a justice system that some violations of rights must happen. And this is where Section 36 comes in and talks about the limitations of rights. And an arrest is lawful, or arrest per se are allowed and, in a sense, necessary for policing, for justice, in order to bring accused persons to trial. And so allowing that means that we have to be vigilant of what is involved in arrest procedure, meaning that just because peace officers, and as you would have seen through the slide, even regular citizens like you and I are allowed to and permitted in terms of the Criminal Procedure Act to perform arrests, to arrest people, doesn't mean that we just can, or that we can do it unfettered, and we can do it anyway and for whatever reason we think appropriate. So there are rules, much more stricter rules for arrests, okay? Particularly because what it means for the person being arrested, right? Can you tell me about a news item that involved arrests? It doesn't have to be a South African one. I don't know which one you're thinking about, but speak to me about that arrest. It was an American one. Do you watch the news? talking about police brutality. So again, when we're talking about arrests, then we also got to talk about use of force when effecting arrests. And that's what we're going to talk about at the next set of lectures. But I'm using that as an example now to put into perspective what an arrest involves and why we have to be treat it as a last resort. When there are summonses, there are written notices, there are warnings, there are indictments. Why do we, or why should we not go to an arrest as the first option? So with the limitations of rights, and if we, in terms of Section 36, with the limitations clause rather, we have to ask, can the same object be achieved through less drastic, less severe, less encroaching means? So those are the questions that we ask. What is the object of a summons? What is the object of a written notice? What is the object of an indictment? What is the object of a summons? What is the object? What is its purpose? All of them, they have one purpose.
To get the accused to trial.
Get the accused to trial. Whether it's a summons, the point of giving the summons is to get him to trial. If it's a written notice, the point of issuing this written notice is to get him to trial. If you're arresting him, the point of arresting him is to bring him to trial, right? But there are different ways of getting to the same purpose, correct? The same object. You can use a summons or a written notice or an arrest. So this is what we're talking about. Can the same object be achieved through a less drastic means? Now, we're not saying that in every single circumstance, arrest will never be appropriate simply because it is drastic. No, circumstances may require that the only appropriate manner in which to secure the attendance of the accused at court is an arrest. And that we'll talk about the circumstances later, but that could be because of the nature of the offense, because of the timing at which the arrest is being effected, okay? Whether or not the accused person is a danger to other members of the society, other members to himself, and it mirrors a lot of what we're considering when we talk about bail matters, right? But you see that there's a lot involved to justify why I've resorted to an arrest as opposed to a summons. Now, that being said, when we go back to circumstances, it might be a situation where it would be imprudent, in other words, impractical for a police officer who's on duty, who witnesses a crime or sees something happening and says to the person, listen here, I'm not going to arrest you because that's drastic. That's drastic. So what I'm going to do is, you wait here, I'm going to go to court and I'll either get a warrant of arrest or I'll ask them to do up a summons for you. But wait here, I'll go get it and I'll come back. Now, clearly that's ridiculous. That's ridiculous. Okay, we don't know any much more about the facts, but it may very well result in the fact that these suspects simply just walk away and the peace officer can never find them again. And so that's where and why we talk about arrests with warrants, arrests without warrants, and the value and purpose of each, that each serves to in policing and prosecuting of crimes. So we can take you through. So what you need to look at and what you would have covered in your slides are arrests with warrants and arrests without warrants. Now, arrests with warrants obviously would be the best possible scenario. But we also know that the reality of life and the reality of policing and what is involved and required of policing may necessitate that an arrest be conducted without a warrant. So look also under what circumstances an arrest without a warrant would be justified. Yeah. And also look at arrests by private citizens. So what would be called citizens arrests. Does such a thing exist in South African law? Is that only something we see on TV? It exists. It exists. So have a look at that. So I'm going to move us along then to our tutorial question, which you would have looked at. Discuss the purpose of arrest in light of the decision in Sex Worker Education and Advocacy Task Force versus Minister of Safety and Security 2009. How did you deal with this question? Anyone? Let's start by asking, what type of question is this? What type of question is this? Anyone? Is it a problem question? Is it an essay question? What is it? Anyone attempt the question? Have you attempted the question, guys? All right, so that brings us to the end of our session. All that's left for me to say is that I made an announcement at the full-time class that your assignment is due on the 26th. And so in order to allow you time to complete your assignment timelessly, we won't have next week's Zoom session. Your assignment is due on the 26th, and I will see you all on the 27th for that Zoom session. Please be prepared. This was rather unfortunate. Any questions about the assessment?
Hi, Miss B.
Who is speaking?
Kasurea Raja.
Oh, hi, sorry. Go ahead.
Sorry, ma'am. I just wanted to ask you something because I know we're not having a Zoom next week. My question relates regarding to the assignment. I was looking at well, I'm working on it, and I was looking on the topic and stuff, and I wanted to know with regard to my approach, do I have to take an informative or must I take like the essay form of an informative essay or an argumentative essay? And should it be something like for or against restorative justice and mediation in the criminal justice system?
Well, it could be both, you know. You could be writing to say restorative justice as a system has place within the criminal justice system, but it cannot be used, and this, well, I can't answer the question for you. Although it has a place in the criminal justice system, it is not the be all and end all. In other words, if you feel you can motivate to say that it belongs in respect of certain types of offenses and in relation to certain types of offenders, and here are the examples where it could work, but where there are more serious offenses, for example, whatever, I mean, look at the writers, see how the writers have argued it. Because you're not saying, look, scrap the whole of the court system, scrap courts, scrap jails, blah blah blah, and only go with mediation. That's not what any of the authors are saying, are they?
No, they're not.
So you're not making really an example of for or against. You're saying this is the system, this is how it works, these are the benefits, and this is where it could possibly work within the system we already have. Not to scrap one over the other, not to say that one is better than the other. It all depends on the circumstance.
Oh, okay. Thank you so much, ma'am.
Okay. Anyone else? Let me formally also record my disappointment regarding your lack of preparedness for the tutorial question. All right, so I'll see you all on the 27th then. Thanks, everyone.